One of the major concerns for any hopeful parent who's considering going through surrogacy is, can the surrogate keep my baby? So let's talk about that. What's up? I'm Corlandos Scott, a surrogacy attorney in Los Angeles. So I handle all of the legal work involved with helping people grow their families through the help of assisted reproductive technologies like surrogacy. Now, in today's episode, we're going to consider whether a surrogate can keep your baby in California. But I'll also speak generally about other locations too. But first, we'll cover the general rule and some possible exceptions to that rule. We'll look at gestational surrogacy versus traditional surrogacy, and we'll talk about the ethical and legal implications of it all. Let's dive in. Now, if you've been rocking with me for any length of time, then you've heard me say that not all states are created equally when it comes to their surrogacy friendliness and their friendliness towards surrogacy arrangements. There's no federal or national law, you could say, that addresses surrogacy, so each state has the right to create its own laws and regulations around surrogacy. So it makes sense that each state approaches things differently because they're different. So when I mention that there's a general rule and an exception, just know that the location or jurisdiction, as it's referred to legally, that jurisdiction plays a role in what the rule is and whether there is an exception. So what is this general rule? The general rule is that when there is a valid surrogacy contract in place between a surrogate and intended parents who were both represented by independent counsel and that contract was executed prior to the embryo transfer that got the surrogate pregnant, then the surrogate has no legal right to keep the baby. But I mentioned an exception. What is that? Well, the exception to this rule can potentially happen when you don't follow the guidelines outlined by the law. When you don't have a contract in place, or even when you have a contract in place, but that contract doesn't meet all of the necessary legal requirements of a valid surrogacy contract. The exception can also happen when you and the surrogate don't have separate, independent legal counsel. The exception can happen when your contract isn't signed in front of a notary or when the contract isn't notarized prior to the embryo transfer. In other words, what I'm saying is you put yourself in danger of the surrogates having the right to keep the baby when you don't follow the guidelines for a legal surrogacy arrangement. Now, that's why it's so important to work with an attorney who understands the process and can make sure that all of your legal ducks are in a row. Surrogacy requires a serious financial commitment, and everyone who goes through the process is smart to find ways to minimize the costs as much as possible. But listen to me, skimping on an attorney is not one of those ways you should save money. At the end of the day, what good is a successful surrogacy birth if you're not legally able to be the parent of the child that was born? So let's look at gestational surrogacy versus traditional surrogacy. But before I do that, let me take this tangent. I often hear people refer to surrogates as surrogate mothers. Now, understand, I get it. I understand the verbiage and I don't get hung up on people using the phrase surrogate mother. However, I personally stay away from using the phrase surrogate mother. Why? Because the whole point of a surrogate and a surrogacy arrangement is that someone else will be the mother or father, not the surrogate. Also, the surrogacy contract that you have should go into painstaking detail about how the surrogate has no maternal rights or responsibilities. So to draft a 50-page document that repeats over and over and over that the surrogate is not the mother, not the mother, not the mother, flies in the face of calling her a surrogate mother. That's why you'll hear the phrase carrier or gestational carrier used in conjunction with surrogate. Okay, off my tangent, back to your regularly scheduled programming. Now, this is a good time to discuss the whole gestational surrogacy versus traditional surrogacy thing. I've mentioned in other videos that traditional surrogacy is very seldomly used, and I always advise my parent clients, and my surrogate clients for that matter, against doing traditional surrogacy journeys if they at all can avoid it. Now, a traditional surrogacy arrangement is where the surrogate who is carrying the baby is also the egg donor whose eggs went into creating the embryo. So in a traditional surrogacy arrangement, the woman giving birth to the child is, in fact, genetically and biologically the child's mother. Now, as crazy as it sounds, many people get a picture of the TV show The Handmaid's Tale when they think of traditional surrogacy. But again, I advise my clients against this route if they can avoid it at all, and really not many hopeful parents opt for this arrangement because of the additional element of having the surrogate be genetically related to the child that she's carrying for them. Now, this type of surrogacy arrangement is legal in California as long as all of the typical surrogacy legal requirements are met. You shouldn't have any legal roadblocks to growing your family through traditional surrogacy in California. However, there is the added psychological and emotional element of the surrogates being the actual genetic mother of your child that she is carrying and will deliver and will have to separate from at the time of birth. Now, listen, that's not an impossible feat for someone who has already agreed to be a surrogate and said they understood how surrogacy works. However, it's definitely an added emotional and psychological consideration, and you have to recognize it and definitely plan for it. Now, in cases outside of California, though, traditional surrogacy arrangements may just hinder your ability to be declared the legal parent of your child for the simple reason that the surrogate is genetically and biologically the mother of the child that she'll deliver on your behalf. Now, if you're curious about how other states view surrogacy, make sure you check out my video on surrogacy laws in the US. Now, the craziest case involving a traditional surrogate is the Baby M case for sure. Now, the Baby M case is a case where a traditional surrogate demanded physical custody of the baby after giving birth, and she even went so far as to kidnap the child. Yeah. Now, the contract was ultimately deemed invalid, and the baby was returned to the intended parents, but the surrogate was still given visitation rights. Can you imagine that? You have a child, but another person has the legal right to visit your child? Now, this case caused surrogacy to be illegal in New Jersey and New York for decades to come after that. In fact, they're just now jumping back into the game after decades of no surrogacy following the Baby M case. Now, for all of those reasons, the most common type of surrogacy arrangement is the gestational surrogacy arrangement. Now, in the gestational surrogacy arrangement, the embryos that will be transferred to the uterus of the surrogate, they're created using the egg of the hopeful mother or the egg of a donor who is not the surrogate. So in a gestational surrogacy arrangement, the surrogate does not contribute any genetic material. So the fetus that she's carrying for the hopeful parents is not related to her genetically or biologically. It is not her genetic child. And that's why most times we refer to surrogates as gestational carriers, because they are simply carrying and gestating the hopeful parent's child that was the result of embryos that are not connected to the surrogate at all genetically. So my advice to you is the same advice I give to my clients. Avoid traditional surrogacy arrangements and opt for gestational surrogacy arrangements if it is at all possible. Now, before we talk about the legal and ethical angle, do me a favor, hit that like button. Of course, these videos are free, but hitting that like button is like a little pay it forward that you can do. Why? Because it helps YouTube know to share this video with other hopeful parents who may have the same question. And I'm pretty sure it brings you good karma. Trust me, just click it and see. Oh, and while you're down there clicking like, just go ahead and subscribe to the channel so you don't miss any of my upcoming videos. No one likes to miss out, right? FOMO. Okay, the good news for you if you're doing surrogacy in California is you're covered where it concerns a surrogate's ability to keep your baby. When you do it right, she simply can't keep your baby. And I should also mention that you do not have to live in California to embark on a California surrogacy journey. I have clients from all over the country and all over the world who decide to find a California fertility doctor and a California surrogacy agency and a California attorney to help them in their surrogacy journey, even though they live in a different state or different country. Why do they do this? For the very reason that California is probably the most surrogacy-friendly state in the world. In fact, here's a story about a resident of the U.S. state of Georgia who grew his family through surrogacy with the California surrogate, and the surrogate tried to keep the hopeful parent's baby. In 2016, surrogate Melissa Cook was carrying triplets for a single intended father. Now, the intended father requested that the surrogate reduce the pregnancy due to a concern over the health of the triplets. The surrogate disagreed and took the position that the fetuses were all fine and that if the intended father didn't want all of the triplets, then she would still deliver all three and then she'd keep the one that she felt the father didn't want. Wowzers. Well, even if you were to take the surrogate's position as well-intentioned, the law in California is clear. The 75-page long surrogacy contract between the surrogate and that intended father spelled out the terms of the relationship between those parties, and the agreement validly complied with all of the legal compliance. So, the surrogate's claims and arguments were described as an all-out attack on the constitutionality and enforceability of surrogacy agreements in California, and the trial and appellate court ruled in favor of the father. Now, this is the reason why many hopeful parents choose to work with California professionals for their surrogacy journey. Whether or not you did your surrogacy journey in California, just make sure that your state provides you with protection so that you don't find yourself in a Melissa Cook type situation that goes against you. I like to examine the ethical angle of this topic because oftentimes the legal really flows from the ethical. Now, the major ethical concern in a conversation on the surrogate keeping the baby surrounds unreasonableness or abuse of the surrogate's rights. So we have to make sure that in any surrogacy arrangement, that's traditional or gestational, we have to make sure there's a valid consent from the surrogate around exactly what will happen in the process. We should make sure that neither of the parties is disadvantaged or at a disparate ability to negotiate the terms of the arrangement. In fact, reputable surrogacy agencies will not even accept surrogates into their program if the potential surrogate is receiving government aid or government subsidized living in any capacity, like welfare or food stamps or any other kind of government aid. Now, hear me out though. The philosophy behind this policy is that the agency does not want the surrogate to be perceived as solely relying on the compensation she's getting from the surrogacy arrangement as her sole source of livelihood. Now, when that happens, that could give rise to the question, are the hopeful parents taking advantage of a woman who's financially strapped for cash and she's looking for a way to survive and she's looking to this surrogacy thing as her only option financially? We don't want to be perceived as taking advantage of a person who is not financially stable. So that's why surrogacy agencies will require that surrogates have some type of financial stability outside of the compensation they'll receive in the surrogacy arrangement. And even if it's not one of the agency's policies, I also advise my clients against working with any surrogate who may even be perceived as using the surrogacy compensation as her only form of livelihood. Now, this concept is also the underlying philosophy behind why many states only allow altruistic or uncompensated surrogacy. Now, another one of the ethical considerations is whether there was a medical need for the surrogacy or whether it was simply done for vanity or convenience of the intended parents. Most fertility doctors find it unethical to subject a surrogate to the type of medical and physical risk that accompanies a pregnancy if there's no medical need to do so on the part of the intended parents. So, whenever there is a disconnect between the rights and interests of the parties, there will be legal and ethical implications. So whenever there's a disconnect between the rights and the interests of the parties, there's going to be legal and ethical implications. So make sure you have professionals around you who can help you wade through those safely. And if you're looking for help navigating the surrogacy process, I have something just for you. My free Surrogacy Secrets seminar. And this is where I walk you through how to navigate the surrogacy process without losing sleep, time, or money. So if you want it, it's yours for free. Just click the link in the description below and I'll see you there.